This. And also to remember that we. Yeah, we can do it. One to one hard for.
Okay, say make it 20.
Lordship, interim may be extended.
You take it consent of the other side.
Yes, Lord. I appeal for respondent 4.
You appear for the respondent number 4.
Yes.
I appear on behalf of the appellants, your lordship. Lordship, interim may be extended, your lordship.
Interim order passed till this stands extended.
Much obliged.
May I please, Your Lordship? With regard to item number 23 and 24 of today's case, my lord, we are making a joint prayer, my lord. The matter has been substantially heard by court number 1, my lord. So the matter may be taken up any other day. my lord.
Both sides are represented. And it is submitted that the matter has substantially been heard by the bench of the Honorable the Chief Justice. Accordingly, this is the matter before the said bench. Accordingly, matters been adjourned.
If it may come up on 18th or 27th, 18th or 27th.
Okay, 2011.
Obliged, Lord.
Ma'am,
My lord,
Lord.
the date has been given 18th. The date has been given as 18th or 27th.
20.
20th, Mr. Mishra has some difficulty. On 27th, my lord.
27th.
27th. Obliged.
ma'am. In item 19, my lord. I have filed an application, my lord, to withdraw my name, my lord, from the case. That also application is there, my lord, in the record. Others will be there, my lord, only my name may be withdrawn. Maybe allowed.
The IA has come.
No, not I, only seeing on page application. Application, yes,
You want the name to be struck off.
my name.
No, that can't be done. That cannot be done. Have you complied with the requirement of rule 68, 7 and 68?
I have given application, I have informed the parties, my lord.
Then let the matter be taken up, not at the mention stage. Let the matter be called.
May I please, your lordship, the concern of the appellants and other response, I beg to mention item number 15, lordship. It will be kindly taken after 3 weeks.
15, what says are represented? On the- You are saying on behalf of the state of Mizoram.
Yes, lord.
This is a representative of the prayer made by Learned Standing, Learned Committee Advocate for the state of Mizoram. The matter is adjourned today. Based after 3 weeks on a date to be fixed by the registry.
Much obliged.
May it please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 22, lordship. My senior colleague is out of station, lordship. 22.
Simple. Well, it is not ask for the petitioner, the matter stands adjourned today. This after 2 weeks.
My lord,
After registry.
My lord, my date may fix, my lord, on 18th of this month, my lord, 18th or 24, my lord,
24, lordship.
24, November. I love. My name is recorded, fine.
Both sides are represented.
May it please your lordship. Lordship, an adjournment request was circulated with regards to item number 3 and 4. In this matter, instructing counsel Mr. KP Pathak, he has a medical emergency at his household, your lordship. Therefore, he could not be here today. So I kindly pray for a short date, your lordship, and adjournment on that. Only for the day, your lordship.
Item 3 and 4.
We will also be filing an affidavit with that regard today, your lordship. And for the respondent, my lord.
Both sides are represented. On the prayer made on behalf of the Learned Counsel for the appellant, the matter stands adjourned today.
May
This after.
it be fixed on
Lordship,
26th of November, man. 26th of November.
It's not come.
26, 11, 20.
Yes, sir.
My lord, item 22 supplementary list. We have some urgency in the matter, it may kindly be upgraded.
22.
Yes, supplementary.
22 has been adjourned, you are not there.
আমার কিছু নাই। 30, sorry, my lord, 33. 33. Abhiram Das.
There is 33 review petition.
Yes.
Okay, we'll call, let the admission be over, we'll call it.
Out.
Yes.
They released item 1 for admission.
May I please your lordship? Mr. Payeng will address in this case, lordship. For the time being. For the time being. It's two for the two. That two, huh? That two. That two, night two.
My lord,
Have to be like them.
Supplementary item 29 for motion.
Please, your lordship. My lord, this is a contempt petition, my lord. So this is a contempt petition and the order, my lord, relevant portion of the order is at page 11, my lord.
Where is the order, page number?
11, my lord. Relevant portion,
11.
11.
No, 11 is a part of the,
Contempt petition, my lord.
oh no. This is 29. Some wrong file has come. Some mistake. Read up at 362. Just wait, some incorrect file has come.
Item 29 contempt 570/20.
Page 11, my lord.
Yes,
May I read, my lord, the relevant portion?
we have seen that.
Yet, my lord, it starts from
what is the
we therefore
contempt?
consider, my lord.
What
Your
is the
lordship may
contempt?
kindly see at the bottom, my lord. At the bottom, it is given while passing the order, after hearing the parties, the executive officer Silchar Municipal Corporation shall also look into whether the construction activities are carried out despite stoppage of the work order by the corporation, and in case it is found necessary, coercive steps shall be directed to be taken. But the construction is going on till today morning they are constructing. It is going on day and night, my lord, and it has not been stopped as yet, my lord. Only a letter has been issued for my lord, for
See, we are-
hearing, my
We
lord.
are now so technologically advanced. You don't even take a photograph, show the timeline and the location. where the construction is going on, you are making
Yes,
a,
I have got, my petitioner has sent video recording yesterday also.
oh, video if we play, I will be
My
happy.
lord, in the,
No,
in
no.
the PIL, I have, my lord, annexed the photographs,
Yes,
my lord.
sorry.
Photographs are there
I
in the
understand, but
PIL.
in contempt, what is the matter?
Matter is
If we
regarding
see, if
illegal
we see
construction. my
videos
lord.
here for construction, then the first half is gone. Normally it takes 3 hours time for a movie to end.
My
You
lord,
could have given one photograph at least showing the location where the work is going on. You could have
it
understood
is
that
given in the PIL, my lord. I have annexed, my lord. In the
PIL is
PIL.
prior to the order.
Yes, my lord.
Where is the contempt? That the construction is going on, what is the proof except for your letter? In your letter, you don't also say, this page 13, you don't also say that the construction is going on, stop it.
My lord, here we have only informed and, my lord, the order has been, my lord, forwarded, my lord, submitted before the
Then where is the
authority.
contempt?
So, my lord, the construction is going on, my lord. I have informed the learned counsel of the department, my lord. I have also furnished him the video recording also. And the learned counsel for the department has over telephone, my lord.
Can you obtain a photograph and produce it before us tomorrow? We'll
Ye-
place the
yes,
matter
my lord.
tomorrow
At 2
Let-
PM I can produce, my lord.
at 2.
Yes, my lord.
Okay. You see, I, in the bench, I speak for myself. You see, the statement made in paragraph 3 is sworn as matters of record.
Yes.
And that's why we are asking you, where is the matter of record? That you don't say.
Yes, my lord, I'll place, my lord. I
Paragraph
have
is
got
matters of
photographs,
record.
my lord.
There's nothing on record to show that the construction is
And the
going on.
photographs are showing time and date is.
Because you see, you gave a vague notice. You don't even tell the authorities that the construction is going on. How will they,
My lord, I
what
have
is the
sent-
urgency
my lord,
for them?
inform the learned counsel for the department.
Don't inform the council, then though no contempt is made out. If you inform the council, then no contempt is there.
Then, my lord, even my lord, the learned counsel over telephone, my lord.
I
asked
don't
them
believe
that-
on this statements made to the learned council.
Then, my lord, I'll place the photo. I have got the photographs, my lord, which is indicating the time and date, my lord.
Yes, because otherwise
2
we
PM.
don't have any material.
Yes, my lord.
At 2, there's no bench. We'll have to take list it tomorrow.
Then tomorrow, my lord.
In the writ petition, Mrs. S.B. Chaudhary and counsel for the petitioner, there is no material on record to show that any construction is going on pursuant, yeah, even after. Twenty-four, 10, 2020, 27, 10, 2025. On the date when the order of this court passed on 22, 10, 2025 in PIL 45 or 2025 was served on the respondent. Next, accordingly, the learned counsel for the petitioner prays for an adjournment to produce a photograph showing the construction going on at the site.
I'll
Based on-
file an additional affidavit today, my lord.
However, you want to bring it. List on, make it tomorrow. 7/11/2025.
Obliged.
item 30 for motion, WBC 6203/25.
May it please his lordship. The impugn order, page number 105. In this matter, lordship, the petitioner and his father were declared Indian in the year 2014. Thereafter, the same tribunal declared the petitioner as a foreigner, lordship.
Where's which page is the opinion?
105, impugn opinion.
105. And where is the other opinion of your parents?
Yes, lordship. Page number 84, father's opinion.
Where is your written statement?
Page number 16.
See, the proceeding in this page 84 is Natu Bali, correct? Now come to page 50.
Page 50. Yes, lordship.
Now you have given so many aliases of your father.
Yes. So many addresses of father. So many addresses.
Originally.
In the opinion, there is no link to your father. You don't stay together. You don't vote together.
Total is 1997.
In your is your father alive or not alive?
Right.
Lordship, he is not alive.
Huh?
He is not alive.
Where is the statement in the written statement that he is not alive?
16.
The date of death?
Lordship, in page number 5, there is a statement. The father of the petitioner died almost 6 and 7 years ago, Lordship.
Heard Miss B. Das,
Yes,
I'm
Lordship.
counsel for the petitioner and so and so for the respondents. Opinion at page 105, dated 30/11/2024, asked by so and so in FT case numbers 20. SP reference case numbers so and so dated. thereby declaring the petitioner to be a foreigner of post 25/3/1971 The learned counsel for the petitioner has submitted that the projected father of the petitioner, late Mohammed Natu Wali, Natub Wali, was declared to be not a foreigner by opinion dated 1/4/2014, passed. This was the page 84. Application was controlled, reference number controlled. Thereby declaring the his projected father to be, okay, that it's clearly there. Next one. Either as it may, you should notice returnable in 4 weeks, extra copies within 2 days, call for the relevant record from the consent tribunal. To the following email address. The here for bail is opposed by the understanding for the FT matters. Considering the projection made in the writ petition, 10 days time to take bail of rupees 5,000 to the satisfaction of Supreme Court Police Border Nalbari. List of after 4 weeks on the seat of records.
Motion item 31, WPC 6221/25.
Yes.
May I please, Lordship? Lordship, opinion dated is 4/10/2023, page 31, Lordship.
What I could see. Okay. Right. The learned counsel for the petitioner, administration for the respondents. Opinion at page 31,
31, Lordship.
dated 4/10/2023, passed by its info. In case number 24, SP reference number 24. They were declaring her to be a foreigner for 25 street. So notice returnable on 5/12/2025, extra copies within 2 days, call for the relevant record from the consent tribunal. The here for bail shall be considered on receipt of the tribunal's records. In the meantime, if the petitioner, namely, Akrima Bibi alias Akmila Bibi is apprehended, she shall not be deported out of the country without order of the court. Next one, list also is.
Lords. Doubly obliged.
Upgraded item 33 for orders. Review petition 47/2024.
Lordship. May I please, your Lordship, my senior is on legs, kindly pass over the matter for the timing.
Upgraded item 34 for orders IA Civil 3477/25.
I file a IA for a very limited pair. মাছ বলি নাখায় যে বলি খালি নহয় নহয় ঠিক আছে এইটো কৰিলে মই হেৰিং এটা ফিক্স কৰিম This I was filed by respondent, my lord, respondent number. Here the writ petition was allowed. And against that, my lord, respondent number 5, my lord, filed a writ appeal. And in writ appeal, there is a status quo order, my lord. So already it was fixed for hearing, but it was not been listed for hearing. In the meantime, my lord, they have floated, my lord. They try to, my lord, by slightly changing the name, my lord, they try to, my lord, give it to another party, my lord. This third party, my lord. So my prayer is very limited. Let the matter be listed for hearing in a particular that, my lord. And according to convenience, my lord. And my lord, at least the status quo or past earlier had been maintained, my lord. Already there is a status quo in this area, my lord.
My lord, I have instructions. My lord, I have instructions.
Just a moment. How are you showing that these are two
No, my lord.
mining area with a different name?
My lord, that your lord says cement, sand and gravel government permit area. Now, earlier there is no permit area, my lord, 1 or 2. Nowadays says 1. But according to us, my lord, this is the same, my lord. If my lord, they says that, my lord, this is separate one. We are the status quo order passed by this honorable court earlier is still, my lord, exists, my lord. Then, my lord, I have no objection.
My lord, I have instructions. What has happened?
That be recorded, my lord. Because why?
With a map is there is, my lord. We have maintained status quo. This is a different area. And because, my lords, we have this sub-urgency, my lords, the construction has to also commence, my lord.
Just show it to Mr.
Yes.
No, my lord, all right. Your lordship kindly record the statement, my lord.
Check the positions.
Itu ya di situ tak nice boy kita kan mau lagi.
All right, then all right.
Installation have come because a DFO was sent a notice by the council for the petitioner. So they have written to us also.
Then, my lord, your lordship kindly fix the matter for hearing in the first week of December, my lord. Because even otherwise, last, my lord, is a 5-year contract, my lord, 5-year lease, my lord, next year it will be over, my lord.
Yeah, no. They did up fix
My lord.
fix it.
December 3. December 4. Your lordship, find page 42 of the APD table, my lord. Your lordship will, NIT will get, my lord. The area was, my lord, that, page 42, my lord,
Just why.
page 42. The retable, my lord. Cement, sand and gravel mining concession area. Let me take monthly. Port of Bhayat. Port of. Port.
Hearing today.
Port December.
If my lord takes up the IA, lordship will,
That's fine.
my lord. Coordinate দিয়া আছে তো।
Page 42 হতে আছে।
No, no, coordinate দিয়া আছে না।
All right, no, no.
Mining pin to go hello.
No, মই তো একই করছি, কিন্তু এটা কি আছে?
এটা থাকিল, এটা পুরো পোস্ট থাকিল।
ঠিক আছে। ডিসেম্বর 2 বা 4 কারণ বহুত গীতা ঠিক আছে অনেক ঠিক আমি মনে হয় আমি কিমান কোটি দিছিলো আমি 3 কোটি দিছিলো না হ্যাঁ 3.1 না
My lord, lordship will kindly appreciate one issue, my lord. Red marks are the,
earlier
yes. Yes.
no this one is now my lord they are
Now
doing.
we have created, my lords, we have created this. No, no,
No,
No, no,
I
not
am not
there. It's-
Mr. Big Sir.
No, he's
It's
the
yet to be
repellent
decided.
he's the repellent
He's the appellant.
Appellant.
he's the
Yes, my
repellent.
lords.
And in fact, your
I am the
lordship,
writ petitioner
my client has also informed me that there is some processes going on for certain, but I don't have any document, therefore your lordship. I
These
have not-
red areas are in red. It is that in dispute between these
both of
two
us
parties.
fighting for one
Yes,
I think now my lord
Yeah.
but changing
These are the red, my lords. It's red area. And that new area, it's yellow area. Ah. Well, it doesn't depend upon the area. It depends upon the availability of the
Of the
minerals.
minerals
A area may be small, but minerals may be high. Well, visibly, well, that what lordship is holding, that yellow color is bigger one, big area. But what has happened, my lord, in that area maybe
But it's 3
no, the bigger area, the resources may be spread out. Some might be thick. Lordship will kindly
I got to kiman hector asle moi
hectares. Oh, I get it.
now 3 point I got to 4.9
My lord.
my lord it is my lord 4.9
4.9 hectare. 4.9 hectare.
and now 3 hectare
3 hectare. I have an answer to that. My lord, we kindly come to the page of the, page number. Uh, page number 10 of the IA. 10 of the IA. So, my lord, it's a translated copy of the IA. My lord, no, my lord, there's a table, my lord. Oh, yes, 11, there's a table. GPS coordinates are there. Yes, and against that GPS coordinates, a mining plan is made, my lords, and only after it's given sanction, this order is passed. So if lordship directs, I can place the GPS coordinates also. Maybe this might be, my lord, this is not a work of an expert. This is a ranger. So if that be so, my lord, the expert body, which prepares the mining plan, I can bring it.
No, no, I'm
No,
not,
no, we are not infringing. Visibly, I'm infringing. This is
no, I'm not disbelieving, my lord. Your lordship can keep it as a part of the record. His statement is a different, my lord. His statement should be recorded. And may I pay that, my lord, since, my lord, although I am the highest bidder, and next year it will be over, my lord. So, my lord, may I pay that it will fix our hearing either on 2nd December or 4th December, my lord.
Second, your lordship will be
2nd December.
convenient.
Should be taken up by Honorable the Chief Justice. We don't want to pass an order directing Chief Justice to take up a matter.
My lord, simply fix a hearing, hearing.
Your lordship.
Yes,
We will fix
my lord.
a date of that day. You
My lord.
convince the Honorable Bench. Heard Mr. T.J. Mohanty, Senior Counsel, assisted by Mr. J. Sharma, Learned Counsel for the applicant. Also heard Mr. D. Gogoi, Learned Standing Counsel for the Environment Forest Department, representing respondent numbers 1 to 4, and Mr. S. Bhattakur, Learned Counsel for respondent number 5. Next part. The applicant as well as the respondent number 5
Of the detail.
are in dispute with regard to the extraction rights of gravel and sand in respect of the mining area covered by tender notice dated 11/6. Your is what tender number?
Case 42, my lord. Tender number, my lord.
Hmm?
42. Tender number 42,
11/6/2021,
my lord.
which is for a period of 5 years. It was here in paragraph 2, you have written 2027 instead of 21, those like.
My lord. Sorry, my lord. It is 21, my lord.
Stop.
21, my lord.
It's okay.
Sorry, my lord.
No, it's okay.
Sorry, my lord.
So in the connected appeal, the applicant is the appellant. Who is the appellant here?
Applicant
Is the.
Respondent number
is the-
5.
is
Respondent number 5 is the appellant.
The respondent number 5 is the appellant in the connected read petition. And the applicant herein is the respondent number 5 in the said read petition, read appeal, not read petition, read appeal. No? Next, it is projected that during the pendency of the connected WA 468 of 2023, the Divisional Forest Officer, Dhemaji Division. Respondent number 4. Has proposed to allow a third party while it, while its letter dated 15/10/2025 to the Director of Geology and Mining from Assam for preparation of mining plans. So it is projected that the said mining plan may infringe the operating rights in respect of the SIMEN, SIMEN, sand and gravel mining contract area, which is the subject matter of adjudication in the connected appeal. Stop accordingly. Next, accordingly, the applicant has prayed for a direction not to allow the respondent numbers 1 to 4 to allow any permit for extraction of sand and gravel from the SIMEN, SIMEN, sand and gravel mining contract area till the disposal of the connected appeal. Stop. The learned senior counsel for the applicant has also orally prayed that the connected appeal be taken up for an expeditious hearing. Next paragraph. The learned standing counsel for the Environment and Forest Department has produced a copy of a letter dated 4/11/2025 addressed to the learned instructing counsel for the appellant, for the applicant, and has also produced a copy of the Google map of the SIMEN sand and gravel mining concession area. And it is submitted that the said map would demonstrate that the other mining area is distinct area from the mining plan, sorry, area of operation of the SIMEN sand and gravel permit area. And in this regard, he relies on the coordinates, GPS coordinates appended to the letter dated 15/10/2025, which is annexed as Annexure A to this interlocutory application, as well as the application. That's all. Next paragraph. Next paragraph. Accordingly, the court is inclined to issue notice on this interlocutory application, which is made returnable on 2/12/2025. So, requisite extra copies of this interlocutory application will be provided to the understanding counsel for the Environment and Forest Department course of the day. Full stop. The respondent authorities shall file an affidavit to bring on record that the two mining areas are different. Next paragraph, list this interlocutory application as along with the corrected appeal for the consideration on 2/12/2025. Next paragraph, the learned senior counsel for the applicant is permitted to renew the prayer for expeditious hearing on the next date of the stay.
Minor. No, it's okay.
Well, in fact, he had agreed that this is a different area, so he was
So
not
I
pushing
agree,
this.
my lord, I am
He
not on
agrees.
that, my lord. Now, your lordship,
He is on the main
your lord,
case.
so the instruction is placed before dishonorable court, when they keep is a part of the record. And my lord, I agree, my lord, there's a defined area as per his instruction, my lord.
And may
Let it be
deter-
fixed for hearing main case on the 2nd of December, my lord. Because already
I
there
can be
is,
disposed of, your lord.
I can be disposed of, my lord.
Full stop. Next paragraph. Different coordinates, huh? Where they strike it from the other part, strike it out. Then say. The learned senior counsel for the applicant submits that the instructions produced may be made a part of record. So he prays that this interlocutory application will be disposed of with an observation that the connected appeal be taken up for expeditious, for out of turn hearing.
No, already, my lord, it was fixed for hearing in the month of
okay.
the February 2024, my lord. Now already.
Interlocutory application stands disposed of
2nd of December, my lord.
in the connected appeal, you'd say. Both sides are presented.
I have annexed the order, my lord. You will also kindly see the page 16 of the Miami case.
TJ Montal and senior counsel assisted by Mr. J. Sharma and counsel for the appellant. For the respondent side, has submitted that as per order dated 27/3/2025, the matter was fixed for hearing in the month of August 2025. So please submits that the matter be taken up for hearing on a fixed date. Next, list the matter on 2/12/2025.
My lord. My lord, keep it, order.
I disposal.
The miscase is disposed of, my lord. Keep it.
Time being item 1.
Record. In this case, my lord, I was supposed to argue on this point. My lord. My lord, here, my lord, may I take the exhibits, my lord. Exhibit A is the 1966 voter list, my lord.
Mr. Prime, we'll take it up at the last part of the day.
Today, my lord.
Complete, today at 2 o'clock, sorry, 1 o'clock is we are rising time.
Yes, my
We'll take it up by 12:30 or onwards. Some miscellaneous orders will complete.
lord.
Obliged.
I now remember after opening the file, I remember why this has been put up for hearing.
Upgrade item 33, review petition 47/24.
May I please, your lordship? My lord, petitioner is a Lat Mandal. And he was appointed as Lat Mandal on 4/7/2006. Case 5, para 2. And after appointment, he was posted at Margarita. Revenue Circle. From Margarita Revenue Circle, my lord, he was transferred to Bongaigaon district on 26/9/22.
Where is the order of this court for which review is sought for?
Yes, that lordship may kindly see page 22. Property portion I am only pointing out. Para 15, page 22. Considering the same, the respondent authority shall not give effect to the order of transfer of the appellant issued by the Director of Land Records and Service PTC Kokradhar under memo number so-and-so dated so-and-so, transferring him from Bijni Revenue Circle to Boroma Revenue Circle up to 29/2/24, and he shall be released from said Bijni Revenue Circle under the BTC on 29/4/24, enabling him to join in Boroma Revenue Circle in terms of the said order of his transfer dated so-and-so, subject to the condition that during this period, he continues to serve in accordance with law. This appeal accordingly stands dismissed. So that was the order passed. Thereafter, the government came in by filing an IA and some modification. Because earlier order was, the petitioner was granted to stay in his place till February, till 29/2/24, but the government sought some rectification of the order, and lastly, this honorable court by order dated 20/2/24 made some modification. Kindly see now page 24. Para 5. After hearing the learned counsel for the parties, we accordingly modify correct that at the paragraph 15 of the order dated 18/11/23 in writ appeal number so-and-so, Abhiram Das persisted of Assam and 6 others, the date 29/4/24 shall now be raised 29/2/24. So 2 months are reduced. So however, thereafter, my lord, keeping in view the order of the appellate court also, that I may file a comprehensive memorandum to the authority highlighting all my grievances. But that was not considered. In such a situation, my lord, I again came to the Honorable High Court. That lordship may kindly see page 33. Property portion, page 35. Page 35, para 5. Considering the matter in its entirety, we require the petitioner to submit a fresh comprehensive representation within a period of 3 days from today, and upon the representation being submitted, the Director of Land Records and Surveys, BTC Kokradhar, shall pass a regent order on the representation within another 15 days thereafter from the date of submission of the representation. Till such regent order is passed by the director, and order of status quo be maintained as regards the transfer of the petitioner vis-a-vis the respondent number 7 by the order impugned dated 26/9/22. In the event the representative is not submitted within 3 days, no further requirement of the director, and also the interim order would not hold good. Now that was the thing, my lord. My lord, here we are seeking this review petition because, my lord, at those times, that is, writ petition was filed and the writ appeal was filed, two important notifications of the Government of India were not included by the then learned counsel.
In this particular post, you are there for how many years?
2006, I was first at Bijni, my lord.
Yes, when did you join this place of posting?
That
many
is,
years?
my lord, on 26/9/22, page 26. So there is reason, my lord. There is, I am satisfying lordship on this point. That is the order page 26, kindly see. This is the order of Director Land Records and Surveys. Serial number 3, Abhiram Das, Latpandal, Bijni Revenue Circle. And thereafter I was transferred on this day to Boroma Revenue Circle. Now question is this, my lord. Those at the time of filing those writ petition and writ appeal, two important things were not brought to the notice of the Honorable Court. On those two grounds, I have filed this review petition that lordship may kindly see page 44. Page 44, para 3, Roman 1.
Just now. Yes, page number.
My lord, there are two pages. Page number, kindly first see page 42, my lord. Para 3. Considering that the government employee who has disabled child serve as the main caregiver of such child, any displacement of such government employee will have a bearing on the systematic rehabilitation of the disabled child, since the new environment set up child proved to be a hindrance for the rehabilitation process of the disabled child may be exempted from the routine exercise of transfer, rotational transfer, subject to the administrative constraints. The word disabled includes blindness or low vision, hearing impairment, locomotor disability, or cerebral palsy, leprosy, mental retardation, mental illness, and multiple disabilities. This is in respect of the child or children of the government employee. But now lordship kindly come to page 44. Para 3, 1. Roman 1. A government servant who is a caregiver of dependent, daughters, son, parents, spouse, brother, sister with a specified disability, as certified by the certifying authority as a person with benchmark disability as defined under section 2R of the Rights of Persons with Disabilities Act 2006. May be exempted from the routine exercise of transfer, rotational transfer, subject to the administrative constraints. Now, lordship, here the parents are coming. Here the parents are coming, and in such a situation, page 45 now kindly see, the term specified disability as defined herein is applicable as grounds only for the purpose of seeking exemption from routine transfer, rotational transfer by government employee who is a caregiver of dependent daughter, son, parents, spouse, brother, sister, as stated in para 3, 1 above. Now, what is my difficulties are there, lordship, kindly come to page 46. This is to certify that Sri Abhiram Das, son of Sri Ananda Mohan Das, is a resident of village Kavatika and serving as Latpandal in the office of the undersigned is found to be a person with good moral character. This is the certificate of my authority that there is no any complaint against me. Now, lordship, there are also two students as children reading at Bijni, But the most important thing is not that. Most important thing is this, Lordship may kindly see page 27. This is to certify that is doctor's certificate, my lord. This is to certify that Bimala Das, as about 82 years, that was in the year 2023, my lord, now 25. So now she is 84 years. Wife of Sri Ananda Mohan Das, a resident of village Jamdaha, Part 2, Post Office Garikabari, PS Manipur, in the district of Bongaigaon, Assam, presently residing at village so-and-so, suffering from various type of ailment due to her old age. At present, she could not move properly without help of others, and now she has been taking regular medicine and routine food. I examined her and found hypertension, blood sugar, heart problem, eye problem, etc. So, doctor has clearly said that my mother is unable to move without a caretaker. The second certificate is issued by Bongaigaon Civil Hospital. Kindly see. Page 28. Certified that Mrs. Bimala Das, as 82 years, wife of so-and-so, so-and-so. Now she is, second para I am reading. Now she is advised to take complete bed rest and needs extra care to carry out her day-to-day activities. Then Lordship would kindly see page 30. This is to certify that Ananda Mohan Das, as about 94 years, this 94 years was in the year 2023. Now he would be 96 years. Son of so-and-so, resident of so-and-so, so-and-so, has been suffering in various type of ailment due to his old age. At present, he could not move properly without help of others, and now he has been taking regular medicine and routine food. I examined him and found hypertension, blood sugar, heart problem, nerve disease, and urinary abnormality, etc. I advise him for regular checkup. So these are the different medical certificates. Then again, another certificate is also there, page 31. Kindly see after 4 lines, he constantly needs an attendant for his daily needs. So all these are issued, all these certificates clearly prove that my parents are totally unable to work properly without help of others, and they require attendant. Now my authority under whom I am serving, he has also certified that my activities as government servant is very good, which I have read just few minutes back. Now, Lordship, all these matters were not brought to the notice of the Honorable High Court at the time of filing earlier cases due to unknown reason by the then learned counsel. Here, my case is another case is this. There is no any house. Lordship may kindly see now page 5, para 3. After 4 lines, Lordship may kindly see. The petitioner was transferred from Bijni Revenue Circle to Boroma Revenue Circle, which has caused immense hardship to the petitioner as he is the only son of his parents, namely Ananda Mohan Das, as 95 years, and Bimala Das, as 83 years, and being the son of his parents, with no nearby relatives close to their house, to his parents. So, my lord, there is no other person who may give care to my old aged parents. So I am the only person. So apart from serving my duties as government servant, I have also to look after my parents regularly, constantly, and without my support, they are not in a position to move. But showing proper respect to the transfer order passed by the Honorable, my authority, my lord, I have joined at Boroma. I have joined at Boroma on 20/2/02/24. I have joined. After joining, I have filed this review petition. That as I have joined, kindly consider
and take me return to my original, the second plus a posting at business so that I may look after my parents. So I have shown proper respect to my authorities' order. And also the considered desired of the Honorable Court, I have joined at Boroma Revenue Circle on 20/2/24. So my humble prayer is this, my lord. Actually, this is a question of humanitarian. His parents are in such a condition, actually they are lying in bed, nobody is there. Some neighboring persons may come at some time or 1 day or 2 days, but every day nobody would come, excepting the sons and daughters. So only, this is the only ground on which I pray that the earlier orders may be reviewed. And as I have shown proper respect to the authorities' order, I have joined at Boroma, so I may be taken back there. And my service is good. It is not that for caring my parents, I have done any injuries to my service. And my authority has given, yes, he is doing his best. This is my humble prayer, my lord.
Yes.
I'm appearing for PPC in the matter. Lordship, first contention is the review petition is not maintainable because there is no error apparent in the face of the record, my lord. My learned friend is relying on an office memorandum, Government of India, whether Government of Assam has adopted the policy or office memorandum. It's not known, my lord. Secondly, your lordship, the petitioner was in lordship, Boroma with effect for 21/4/2007. 18 years have gone by, my lord. First order whereby from Margherita he was transferred to Boroma. It was Bisni, 21/4/2007, your lordship. 18 years he was already in that place, my lord.
He was transferred on
On 21/4/2007.
21/4.
Yes, from then that he is there in Bisni, your lordship.
2007 to TO2.
Till the date the order was passed in 2022, then thereafter my learned friend is submitted, that he had joined a new place of posting, my lord.
26/9/22.
Yes, my.
Till.
And now we have verified, your lordship, it's also come up on record. It takes only 1 hour 50 minutes, my lord, from Bisni to Boroma. Distance is too less, your lordship. And since your lordship, transfer is an incident of service, my lord, whether your lordship will interfere, although it's a fragile issue regarding, my lord,
Here to Dispur, it takes more.
my lord. Yes, because of the administrative exigency, he was transferred from Bisni to Boroma, my lord. So whether your lordship, my contention is that lordship, the repetition itself has become infractuous, my lord, since he had joined in a new place of posting. In the event of the matter, whether you're entertaining the review petition will be lordship. That is my limit.
I remember our High Court has adopted this policy of the central government. And in a case, that was also my case, for some forest official at Shorbog, they were transferred to Rangia. And thereafter, on the basis of these two circulars, they have been taken back again to Shorbog. I have that order. Today, of course, I have not brought, but if my learned friend wants this and this honorable court, then I will produce this tomorrow itself. So far, the distance is concerned, this is not practicable. Because nowadays, maximum rush, sometimes 3 hours also take place. And in addition, I am in office. But my officer has certified that I have been doing good jobs. There is no complaint against me from whatsoever. So, my lord, this is not a question. Always, courts did not always think about the law. Sometimes the discretionary power of the court should be exercised even if there is no provision of law. But here is the provision of government circular, and this is their circular. And this circular has been adopted by Government of Assam. And following that order has been passed. I have also got that order in respect of forest employee. So, my lord, I do not want that so many citations are necessary. Because it is a question of 96 years. So this is a question of you. I don't know when or what will happen. Thereafter, they are at liberty to transfer me to any place. Now, even the neighbors cannot stay nearby their house, as in a very unhygienic situation, these two parents, both are extremely old. So nobody can take care of others. I am the only their hope. And my service should not be a bar to help them in their maximum old age. I think law may not be a bar in providing such type of justice to a maximum old age person.
What is your,
Government,
no, your.
my junior, yes, P Bhomik, my lord.
Yes,
I have 5 and 6.
you have got 5 and 6.
Yes.
What is your stand?
Lordship same stand, by the senior executive lordship, because he was transferred for administrative exigencies, lordship, and distance is not so far, lordship, because we ourselves travel that much time, lordship. Easily take care of his old age parents, lordship. And that notification, Assam government has not adopted yet, lordship.
I
Notification which he has annexed here, Assam government has not adopted yet, lordship.
Yes, Assam government has adopted it.
Revenue? So, করেছে নাকি Assam government?
Parental care, I think it has been adopted.
I have to take instruction that much only. Whether the notification is adopted or not, I have to take instruction like this. Otherwise, the factual part, always, the submitted, that distance between their two districts is very less. And whatever they have are that has already been considered in the earlier proceeding.
Other aspect,
Regarding one is scope of review. Scope of review also may place on judgment lordship.
Mm. 2022 live law, SC 2006.
You are referring to the finance department or the revenue?
Lordship, I am revenue department. Revenue. Lordship, I am as doctor.
Oh, yes, that's the.
Lordship.
Well, not a very short answer. First thing, the policy has been adopted by the government of Assam. Second thing, the Honorable Supreme Court reported case, kindly note down, 2022 live law, SC
Live
2,
law we don't have, you'll have to give us a printout.
well,
Live law we don't have, you have to give us a printout.
yes, I will give. But I am saying, case 266, the Supreme Court has said at the time of transferring a person, with what consideration should be made. So I am giving this today itself after half an hour or before 1 p.m.
Even if the notification is adopted, otherwise the every case has to be decided on its own facts. Lordship. This is the issue. Lordship.
deeply, lordship.
I must also one judgment, if there is even no law, the court may exercise its discretionary power. That judgment I will also provide.
Dispose of.
No, pass what is in chambers, we'll discuss and we'll pass.
Lordship, oblige.
Item 2 for admission.
May I please your lordships? My lord, I am appearing on behalf of my senior lordship. Yes, my name is not here, lordship. Lordships, impugn order is at page 89. The short order, may I read, lordships, page 89. Impugn order is at page 89 dated 27/7 to 18. That the case is the above mentioned OP brief is that OP has been suspected to be a doubtful citizen and the basis of reports submitted by LBO and ER of 1993. Lordship take note in this point. LBO report submitted by LBO and ER of 1939 Dollar LLC. The SPB Dobri Competent Authority has forwarded reference to this tribunal to decide the nationality of the same.
Except for the Kabinama, how do you connect yourself to your projected parents?
My lord, oral evidence is there. My uncle adduced evidence.
Is your
Documents
uncle-
1966.
Is your uncle and your father together in any electoral role?
Yes, lordships, my uncle's name, subsequent 1966, my grandfather's name, grandmother's name. And
No, no,
1970 voter list, grandfather, grandmother.
No, the
That
question is,
uncle's name, I also obtained in respect of my family members, lordship. They separate out, that's how I have not,
the question is whether in any of the electoral roll,
lordship.
your name, your uncle's name appears with your parents or your grandparents?
No. Attained majority after 1970 lordship. They have shifted from original village to another village lordship in the year 1974-75. And after
Is the- is
shifting
the name of the
separate
uncle-
houses,
Is the name of the uncle in the written statement?
a written statement is their lordships, page 72. Paragraph 5 lordships. I have details stated in my family tree of my grandfather's, my father's family. And paragraph 72 lordship will find paragraph 5 that the office grandfather Ashan Ali and the grandmother Shakina Bibi were original inhabitants of village Bunialguri, PS Shorbuk subdivision, Borpeta district, Kamrub, Assam, and 4 sons were born to them, namely Meher Ali, Meheruddin, who is my father, to Aksad Ali, who is the uncle DW2 lordship, and Tomsar Ali and number 4, Monsar Ali, and all of them grew up there. Then would in the they also adduced evidence in the cross also lordships, stated lordships, that my evidence and they have not repeated, even documentary evidence also not challenged also. And learned tribunal find lordship that evidence also not been considered, documentary evidence also 1966-70, as well as except the Kabinnama. Kabinnama is also finding is not this is a private document. This is not a private, this is a public document. Unless it is challenged lordship, so contents are not required to be proved. The effects of decision lordship in this regard will place. And tribunal say that Kabinnama is a private. That is incorrect. That's perversity. My evidence are totally discarded. Whole procedure is lordships committed error upon the face of record. This whole procedure is to impugn opinion is a perverse findings lordship. Not only apart from that, impugned opinion of the tribunal, but also in the whole proceeding also is perverse. I will place the decision lawsuit in this year. And even my evidence, my father, my uncle's evidence very much clear also. And even voter list, electronic voter list stated that not admissible. That is also wrong finding. Voter list, 1963 Exhibit B, 97 Exhibit C, that also discarded. And subsequent voter list stated a post 1971 lawsuit 25/3/1971. And that's are also stated that is not probably it is an electronic document, not admissible. That is also perverse. The very basis lawsuit regarding enquiry, that is totally blank, except my name and my husband's name address, nothing else. There is no enquiry at all. I raised objection in the my WS also, representation lawsuits. There are two of my written statement lawsuits that I have stated also. The violative procedural lawsuits, order 3 of the 1960 court orders.
Your uncle did not prove any electoral role.
Uncles not produce any electoral, but I produced my parents' family name, my brothers, sisters. My name subsequently entered lawsuit. My uncles produced his voter ID card lawsuit. I find.
Voter ID would be 2013, not before that.
But he is not my uncle, nobody is denied. I specifically stated I discharge my burden. Those are my uncles. DW2 is my also uncles. They are my grandparents. They are my parents, my brother's family. I discharge my burden as per Sambandha to like that was even the procedural also. Nobody has challenged this. Unless it is challenged, lordship, then he is not my father. Then certainly I will place the voter list or other thing later my father. In the lordship, kindly say 67
There is,
forwarding report.
Where is the decision that the Kabinama is a public record?
This one lordship page regarding this one the findings of the tribunal lordships. Finding.
No, you said that there is a decision of this court that Kabinama is a
I will place the
public document.
Yes, lordships, Muslim marriage and register books, lordship for the act I will say. Muslim marriage and divorce registration act 1935. Section 23.
Muslim marriage. And not Assam.
Or lordships, I will, if it is not, I will place lordships. Section 23, Lordships. Muslim registered to be a public servant. Every Muslim registrar shall be and be deemed to be a public servant, and his duties under this act shall be deemed to be a public duties.
Just pass it on, let.
Yes.
M18 or power, M18.
Section 23, Lordships. Section 74. Okay, what is the tablet? And in the cabin, my uncle signatures. Cabin number uncle signatures. My uncle's name is there also as a attesting witness in the cabin number also. Accept. The page 45, Lordship, column 45, witness name, Aksad Ali. Lordship. regarding exhibit A cabin naval lordships. And in this respect, lordship, in this regard, I will place decisions of the honorable effects of what is public document. Since it's a public document, formal proof is not required unless it is objected. This is 2009-12 SCC 454. 2009-12 SCC 12 lordships. 12 SCC, page 454. Parties Shamlal, Elias Kuldeep versus Sanjeev Kumar and others. I have only two copies, one of the other official lordships. Paragraph 22 lordships and 23. 21, 20, 22. Paragraph 21. Lordship got it? Oh, married. One of the documents relied upon by the learned district judge in coming to the conclusion that the plaintiff is the son of deceased Balak Ram is Exhibit P2, the school living certificate. The learned district judge, while dealing with this document, has observed, on the other hand, there is a public document in the shape of school living certificate. Exhibit P2 issued by the headmaster, Government Primary School, Jabbal Jamrod, recording Kuldeep Chand, alias Shamlal, to be the son of Sri Balak Ram. In the said public document, as such, Kuldeep Chand, alias Shamlal, was recorded as son of Sri Balak Ram. The findings of the learned district judge holding Exhibit P2 to be a public document and admitting the same without formal proof cannot be questioned by the defendant in the present appeal, since no objection was raised by them when such document was tendered and received in evidence. It has been held in Doshanda Singh versus Jalam Singh that an objection as to be admissibility and made of proof of a document must be taken at the trial before it is received in evidence and marked as an exhibit. Even otherwise, such a document falls within the ambit of Section 74 of Evidence Act and is admissible per se without formal proof. And even my uncle's name is also there in this document. And regarding oral evidence lordship, I place your lordship decisions also lordship. Oral evidence. Yeah. I mean. Oral evidence. I don't have. Oral evidence. I don't have motive more. Putting motive oral evidence.
Oral to put the
Regarding evidence not been discussed or except Exhibit A, other discarded lordship. One exhibit BC, the Bhutalis 1966, 1970 of my grandparents, and others, my oral evidence regarding lordships, your lordships, order lordships, WPC number 82/4/18, Jamila Khatun, Barsa of India, paragraph 4, 5, and 6. Yeah. Then lordships again, another oral evidence lordships. Yes, next lordships regarding oral evidence lordship Farida Khatun 2020 Code GLT page 611 cited lordship 2020 Code GLT page 611 parties Farida Khatun versus Union of India.
Yes.
That is, I have copies, so one copy last. One copy I provided, Sandra.
It's okay.
Paragraph 10, 10, 11, 12. Paragraph 10, the aforesaid interpretation itself gives the petitioner proceed a wider choice of evidence in order to prove her citizenship by any fact from which, either by itself or in connection with other fact, the existence, non-existent, nature or extent of any right, liability, disability asserted or denied in the proceeding necessarily followed. Accordingly, the petitioner has the right to rely various facts which must be relevant, keeping in view the facts in issue. Once the petitioner places the evidence, the tribunal is bound to consider each and every such evidence in order to decide its relevancy and admissibility of the evidence. The search for relevancy and proof of contents thereof in the case of documentary evidence is not the same. Relevancy relates to the facts in issue before the tribunal, which are undoubtedly the facts pleaded by the proceeding, and the degree of veracity that can be attached to it. So the said exercise requires discussions and reasoning, and if there is no such discussion, then it would amount to non-consideration of a particular fact pleaded, resulting violation of principle of natural justice affecting the proceeding. Once a document is held to be relevant, then comes the issue of proving the document and the contents thereof. While searching for the relevancy, the tribunal is bound to consider the oral evidence also along with documentary one, as all facts cannot be proved only by documentary evidence. On perusal of the impugned opinion, it is apparent that the petitioner relied 6 documents, but the learned member of the tribunal failed to discuss 4 of the documents after picking up only 2 exhibits as referred here and above. The member of the tribunal even failed to take note of the oral evidence, which are very much on record, that the certified copies of which are annexed in this petition. In view of the above discussions made, we have the considered opinion that there is an error upon the face of the impugned opinion, as the learned member failed to discuss the evidence on record. And as such, we are inclined to allow this petition by setting aside the common impugned opinion dated so and so in FT case number so and so by the learned member so and so, which we accordingly do, and remand the same with the direction to reconsider evidence on record and pass an opinion as per the law. It is clarified that we have not entered in the merit of the claim of the petitioner on the basis of the documents exhibited.
Your point is right, but submission is wrong. Mr. Sharma, this has to go back.
Lordship,
In the evidence, DW2 was not discussed.
Lordship.
The other, the submission which is making, of Mr. Barbe is making, that may not be acceptable because of page 92, para 3. Page 92, para 3, the submission would not stand. But the point is taken, that has forced that DW2 is not discussed. Reasoning is from page 91. Doesn't have that.
Yes,
So Barbe, for you, page 92, paragraph 3.
yes, Lord. Yes, Lord.
Whatever it is worth, it has to be discussed.
Yes, Lord.
We want the matter back.
In para 91, Lordship, it was mentioned, Lordship, DW2 Akshed Ali, son of late Hassan Ali, in his evidence inter alia deposited. He is an Indian citizen by birth and Lordship, para page 91, Lordship,
Yes.
DW2, fifth line from top, Lordship, DW2.
Discussion.
Yes,
No,
otherwise.
It is not discussion here.
Only.
Written one line,
Lordship.
end of the matter, but it doesn't say so.
Yes.
Mr. F.U. Barbier and counsel for the petitioner. The counsel appearing on behalf of the counsel for the petitioner. As well as so for the respondent. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 89, dated so and so, passed by so and so. Thereby declaring the petitioner, namely Mohidun Nasa, as foreigner of post 25 1971 Steve. It would suffice to mention that on receipt of a reference from the Superintendent of Police within bracket border, bracket the proceedings was registered before the learned member from a foreigners tribunal within bracket Roman 2, bracket was Dhubri, as FT case number 351/F/15, arising out of police reference case number 37/D/08. Full stop. On receipt of notice, the petitioner appeared and filed a written statement and documents, and in support of her defense, petitioner had exhibited 10 documents, has examined herself as DW1 and her projected uncle. Said Ali, AKSCD, said Ali, as DW2. And the following documents were exhibited. Page 90. Sopara 1 to 10. The learned tribunal, on discussion of the exhibited documents and considering the evidence of DW1, answered the reference in favor of the state and against the petitioner by declaring her to be a Pocono post 35, post 1971 stream. The learned standing counsel for the FT matters has made his submissions to defend the imperial opinion. Next, however, it is noticed that under the heading reasoning and decision, inverted commas, in reasoning and decision, the learned tribunal had discussed exhibit numbers A to F and I, and the other three documentary evidence being exhibit G, H, and J. Were discarded. On the ground that they are post 1971 documents, however, without referring to the exhibit numbers. In the said opinion. Next, however, under the said heading of reasoning and decision, there is no discussion as regards the oral evidence, as regards the evidence tendered by the DW2 or the projected uncle of the petitioner. In the case of Farida Khatun versus Union of India and others, 2020 within bracket 4, GLT 611. This court had held that once the petitioner has placed the evidence, the tribunal is bound to consider each and every such evidence in order to decide its relevancy and admissibility of evidence. Next, in this case, as there is, as the impugn opinion does not contain the discussion and reasoning in respect of the evidence of DW2, or the court is of the considered opinion that the impugn opinion dated so page 89 is vitiated by non-consideration of the evidence on record. So accordingly, the said impugn opinion dated 27/7/2018 is set aside. Next, the matter is remanded back for a fresh decision by the learned member from a foreigners tribunal at Roman 2, Dhubri, by considering the evidence of DW2 next para. The petitioner, was duly represented by a learned counsel, shall enter appearance before the said learned tribunal on five 12/25 without any requirement of entrance or service of a fresh notice of appearance. First of the petitioner, by producing a certified copy of the order, wait for further orders to be passed by the learned tribunal. The registry shall send back the records immediately to the learned tribunal. Next matter. The petitioner shall produce a certified copy of the order before the Superintendent of Police order to bring the order to the notice of the said authority. Next matter. According to this, the petition stands partly allowed to the extent as indicated above. Next, but there shall be no order.
Obliged, Doshi.
Item 5 for admission.
May I please, your lordship? As per last occasion's order, Lord, affidavit has been filed by the respondent and we have received the copy. But in this affidavit, my lord, except the order which was placed before your lordship, there is nothing in this affidavit and no whisper regarding the, my lord, that advisory board confirmation order, whether it was served upon the detainee or not. No whisper on this part. the order dated 4/8/2025 that was placed before your lordship, that has been annexed in this affidavit, my lord. And except this, there is no annexure, no confirmation order passed by the advisory board. And regarding delay part, my lord, delay part is also not explained in this affidavit. I have gone through the affidavit. My lord. But regarding those memo letters which were received from the SSP Biswanath, those were not discussed or not mentioned in this affidavit. And my lord, the most vital document, that was the confirmation order passed by the advisory board, and that is also missing. And apart from this, my lord, respondent number 7, that SSP Biswanath filed one affidavit in last occasions, my lord. In that affidavit also, my lord, the para-wise they have just denied, and no explanation regarding delay, no explanation regarding the execution of that order, detention order, that was after 5 days. That was also served on delay, my lord. So that was also not discussed, not explained. In both the affair, my lord, they were silent regarding the delay part. My lord, apart from this, one another aspect, my lord, that respondent number 2, they have filed this affidavit where that they made a contradictory statement with the my lord, affidavit filed by respondent number 7. That they have mentioned that they have received one representation dated 31/7/25, which was received on 13/8/2025. Whereas, my lord, the jail authority, that is respondent number, my lord, respondent number 8, forwarded those representation on 27/7/2025. My lord will first, my lord will come to my petition, para number 5. My lord, at the same time, lordship will come to annexure 8 as well, because that was the forwarding letter, annexure 8, 37, my lord, 37. Page number 37. It was forwarded on 27 July 2025 to the respondent number 3, that is Home and Political Department. My lord, in the affidavit they have mentioned it. They have received this representation on 13/8/2025. But contradictory statement, my lord. my lord. My lord, date in the upper portion dated Biswanath Sarili dated 27 July 2025. Third, my lord, oh, just a minute, my lord. In the affidavit, my lord, lordship will come to, yes, in the affidavit filed by respondent number 2, page number 54. Para number 7, my lord.
On third, my lord. On
Four.
third. 3/11, on Monday, Monday. my lord. It's filed on 4. 4. Record on 4 has it.
But it was filed on 4.
I don't know. Look. Look, I'll just give a request. Lot, one, two. Lot. But can I hand over the office copy? For lordship perusal, can I just hand over it? Two, my lord. I'll just give the requisition, lordship may take up tomorrow. Tomorrow. And affidavit in opposition by the respondent 2 has been filed. 1 and 2, right? 1 and 2 is. 1 and 2. The same is not on record. The senior government advocate shall give a requisition to call for this at record. Next paragraph is upon tagging the said affidavit on record, list again on 7th.
Tomorrow?
Tomorrow.
No, like what?
Be rising, there's a meeting at 1 o'clock.
I have a prayer, my lord. Item number 6 and 8, my lord. Lordship will kindly post it on Tuesday next, my lord. These are, one bail is under consideration and one is for, my lord, disposal. 6 and 8, my lord.
Give it to the courtmaster.
On Tuesday, my
Give it to the courtmaster.
My lordship, your lordship had fixed item number 32 for today, your lordship. Says in detention, your lordship. Your lordship, if your lordship may fix another date, your lordship. Short date, your lordship.
My lordship, item number 10 and 11, my lordship. He is in detention, my lordship. I have filed.
Give it to the courtmaster. Give it take. You want to?
Completely we were told. And in the other case, final report was to be submitted shortly.
Yes. I have read this on it. Okay, it is available. Charge sheet has been submitted in respect of 6 persons.
Yes. That is in Mybang PS 6, 2018.
Yes.
We have not received a copy of the,
It is concluded on 31/10. Now. This is 6.
and Mybang PS 2 was supposed to be submitted to of 2018. The photocopy of that.
Oh, yes, sir.
Yes, yes.
Compile it.
31/10. Take us. This document you have not produced.
Logic.
Look at your instructions.
Yeah, brother.
2 of 2018 was charge sheeted,
Yes,
correct?
yes, brother.
So where is that?
The charge sheet copy, my lord, this was completed, filed on 31/10/2025. We are on 6th, my lord. That copy is not with us. That copy I'll get by this time, my lord. Like, I need some time, my lord. On 3rd, my lord, I have got the instruction.
So,
Well,
Raspa,
Lordship,
once they are making a statement that this has been charge sheeted,
Lord,
we take note of that and proceed. Because there's no point waiting for the
yes,
copy.
Lordship.
We take note of your submission.
my lord, in fact, the written instruction is there, my lord.
Yes.
Logic.
Then the matter would
And the
boil down to the issue of compensation.
FR copy is annexed. In the other case, FR has been submitted, that copy we have annexed.
Yes, that is available.
And the charge sheet, my lord, it was on 31/10/2025, my lord. I got the instruction on 3rd. So some time is required. In the meantime, I'll place.
One copy has been served on me and the other copy, only that liberty may be allowed, your lordship, so that your lordship, in regard to the final report. Yes,
With regard to the first case, that is 6 of 2018,
lordship.
wherein an FR has been given accusing everybody. There you can, if the informant can always file the Naraji petition and get. But with regard to 2 of 18, there is no need for giving any liberty because people have been convicted
Yes.
therein. So therein we have not done, as my lord has said, we'll now have to go and decide the compensation.
Yes, I'm with you. I'm with
This
you.
thing has attained its finality. Now
Lord.
we not, law will take its course.
Lord.
Lordship. Otherwise, the records and affidavits are before your lordship, no? And the
Lordship.
status of the cases we have already placed. Lordship, take up the matter.
Lordship, may I pray like this, your lordship? I have got the documents regarding the compensation scheme and all. But I have sought instruction from my client, actually they are from the interior village of Lima Hasao. And as to how much compensation or if any compensation they have received. So till that, I have not received that instruction till now, your lordship. So if some time may be granted, then I can obtain, because there were 2 dates. Yes, but
Lordship. Look,
End of November.
yes.
Lordship, I understand your lordship.
No, I would pray for the last week of November, on 27th, not if.
Fair enough. I will
27.
So 27th November, if it suits your lordship. Lord.
Second.
2nd December.
Lordship. Second will be, second, if not inconvenient.
You complete your instruction. Yes, I'll obtain the instruction.
Heard Mr. V. Rajpal on counsel for the petitioner. Also heard Mr. D. Nath, the senior committee advocate, along with Mr. H. K. Hazarika, the government advocate. Pursuant to the previous order, the learned senior government advocate has produced a copy of written instructions dated 3/11/2025, received from the Assistant Inspector General of Police within bracket law, comma, thereby informing the learned senior government advocate that Mybom TS case number. This part. Put it. No. Next part. The next paragraph, along with the said letter, comma, a copy of the final report, white number 4/2025, dated 16/9/2025, submitted in connection with Mybang PS case number 6 of 2018 before the Court of District and Sessions Judge, Dimasa, Haplong, has been enclosed. You provided a copy to, I have given a copy of the said letter along with the final report has been provided to the learned counsel for the petitioner. Next part. The learned counsel for the petitioner has submitted that he has sought for certain instructions from the petitioners who resided in interior part of the district of Dimasa. According to matters since John today. List on 2/12/2025. No. Sure, before that, the instructions produced is copy of letter, instruction. Taken of record. Both of you are requested that if any, you are relying on any case citations, please
Yes.
give us at least a week in advance.
Lord.
Give it to the court master. Don't hide it in the sector.
Lord.
Give it to the court master.
Slight accommodation.
Pardon me?
Slight accommodation regarding the date. Can it be on 4th December?
No issue with that.
Lord.
Court, okay,
Wait.
no issue with that. But at least then we'll get time to go through it. Otherwise,
Yes.
2018 matter is getting
Yes.
delayed.
I'll submit the scheme as well as the
whatever they, don't write a very elaborate, what you call synopsis or of the submission which is more than the repetition itself. So bullet points and then case laws be applicated. We have dealt with repetitions where the repetition was 10 page, 11 page was the affidavit, and the synopsis was 12 page. So.
Division bench item 1, WP criminal 42/25.
Okay. Lordship has your lordship, last occasion, your lordship, we have completed our arguments, your lordship. Your lordship has fixed it for any clarification it required, your lordship. And I have also submitted a written submission, your lordship. So, written submission. Grounds, your lordship, were lordship, grounds, your lordship, I have narrated, your lordship. One was to your lordship that the failure to inform about the right to representation before the detaining authority, your lordship, that is one ground. And secondly was delay in disposal of the representation, your lordship. And third is, your lordship, delay in informing about the right to represent before the central government and non-furnishing of relevant material. And finally, your lordship, non-consideration of bail order and then imposing maximum period of detention without citing any reason. Your lordship. These are the grounds on which, your lordship, it was put to challenge, your lordship. And we have already submitted, your lordship, 2 volumes of judgments we have relied on. And one additional judgment was there which your lordship has passed on the condition of bail, your lordship, consideration in a NDPS case, your lordship.
I have made my submission regarding this bail matter. Submitted and I don't make any submission. One submission I got made. People lordship kindly transfer the page, my lord, 44. I think the order starts from page 44.
44.
The order is of 3 pages. My lord, it starts from page 44. My lord, while granting at page 46, lordship will find its conditions start from page 45, bottom, Roman 1. The accused person will appear before the IO as and when called for till the completion of the investigation. This condition has no relevance. Second, the accused person shall not threaten or make any direct or indirect inducement or threat to the witnesses or anyone connected with the case in any form to dissuade him or her from disclosing the true nature, facts of the case or tamper with the evidence. This also has got no relevance. Now, third, the accused person shall not commit any offense of whatever nature in the future. And this is absolutely vague, and by passing an order of bail, if a condition of this nature is given, it cannot be said that, see, this condition is there, in future there is no threat that this person will not commit any offense of this nature. It cannot be. My lord. Yes. Yes. My my lord.
Lords.
Yes. Absolutely, my lord. So far as the question of cancellation of bail is concerned,
And one more thing, your lordship, what my learned senior parenthesis your lordship submitting, the explanation, this explanation should have come from the detaining authority, your lordship. They have not considered, and that is the point, your lordship. They should have considered and say that these are the conditions, these are not viable, therefore I am arresting. That is not there, your lordship. That is my case.
yes. That is what I am submitting, my lord. Your lordship is correct in saying that. My lord, my lord. Law is there, but it's very difficult to submit certain things. Right, thing is there. Yeah. Lawmaker. Therefore, when it becomes more important to speak very carefully and
That is there.
today. Yeah.
Oh, yes, yes, sir.
Yes, madam. Yes, yes. It is there. You're also speaking about the cancellation, it is there. The purpose. Yeah, one. There are, particularly in the early years of profession, the learning about the excitement a young boy has is very important. A young boy, when he joins the profession, boy or girl, when he joins for the profession, he will have certain excitement about some incident. Later, he will realize that that excitement was happening. With time, he realizes.
Lots.
It's not. Not.
About the excitement in early years of profession, about the excitement of a junior boy in the earlier profession. I have got one personal experience that I share with you. And I have always shared with my chamber colleagues many times. Because the case because on this is money, sir. In case of some ad hoc employee, regularized mistake. Somehow I read the fact, my senior argued the matter. I was of the view that we have got a very good case and we are entitled to an interim order. As the argument progressed, the court was against it. We are also aware during both the jurisdiction to be taken by the given day. Somehow the court was against it. I was so excited. In between, I stood up twice to say something. then ultimately, the interim order was refused. I was very upset. According to me, it is a 100% case for an interim protection. I was very, very upset. Till the time after I left the court, till the time I attended the chamber in the evening, I was absolutely upset. Why the interim order was not granted? And I suffered. In the evening when I went to chamber, I was hearing that the senior was not in the chamber. He was in the drawing room with some guests came. I peeped to the curtain and I found that he was smiling, talking, and then tapping his finger on the table. And he came. I said, I suffered so much, but he's happy. His client, not my client. So this is one lesson I learned. This is how we learn.
প্রথমত খুব মানে অ্যাটাচ হয়ে থাকা যায় না?
Item 1 for delivery of order. BA 3078/25.
Obligement. Check that, madam. Obligement.
For orders, item 2, WPC 1754/15.
This is only Kundra Rataras, if I extra copy. So not file to. এখানে ফটো প্লেস করি এখানে ফটো প্লেস করব আচ্ছা আচ্ছা রাখছো হ্যালো এখানে আছে আর জিএলটি এখানে আছে
ফটো দিয়া
জিএলটি
instruction I send it. No, it's not, listen না ধেমাজির এখন মোটা ধেমাজির হে এইটো আছে না কিন্তু কি নাই 60
দিয়া তো এটা
না এখানে
রিপ্লাই
একটা কপি দিয়ে
আর কপি
Yes, my lord. Yes, last time your lordships wanted some details in a tabular format from the respondents. Your lordships orders dated 1/8/2025, my lord. So they are supposed to produce the details in the tabular format before your lordships.
And the 2nd of September 2025 was the last order.
Yes.
And pursuant to that, this written instruction they have issued to my name.
Yes.
मैं राती करू की बदे रात 8টা बजे দিছে না একটা কপি নাই তেনে মই রাতে 8টা বাজে কিন্তু এখানে এই প্রবলেম করতে নিউ দ্যাট প্রবলেম অনলাইন আছে অনলাইন থাকলে পড়াইছি তোমার টেপ আছে না যদি তাতে কমসে কম দিয়া কম চাব দিয়া এগুলো মই ফেস কৰিব বেয়া পাওঁ
ইটোৰ কাৰণে তো কালি এনেকে দেখাইতো মই একোৱে নাই এতিয়া কি কম মই সেইকাৰণে কালি ৰাতি PDF পঠাই দিম মই প্ৰিণ্ট ওলাই প্ৰিণ্টটো কৰি পঠোৱা এতিয়া নেক্সট টাইম মই
But Mr. Mazumdar, it doesn't solve any of our issues.
Yes. Your lordship passed a specific order, my lord, on 2nd September. First of all, with regard to the repair and renovation of the sanitary system works in the FT 1, 2, 3, 4, 5, 6, Kachar.
Yes.
Now there your lordship will find in this report, they are saying to like C2C.
2C, yes.
Yeah. There, I think two DE particularly. And for this 2DE, they have simply written the Public Works Department willing to reply. Now from Public Works Department, certain documents have come. It was you'll also find there is one reply in the form of parawise.
Have you gone and seen any of the three Barak Valley districts? Any court in the Barak Valley district?
No, ma'am.
Even judicial courts?
No, ma'am.
Is all the three districts are in very, very bad shape. The bar room is
Yes.
collapsing. In one of the districts, the chamber of the district judge has a patched up door for toilet inside the chamber. When you enter the bar room, it's a private bar, but the judiciary has a role to play in the maintenance of that also. In the roof, tattered jute, what you call this?
Yeah.
Uh,
Jute with whitewash.
what do you call it? Jute fabric. Those are put up there.
All torn.
Hmm?
All torn.
All torn. So this requires something, and one of the bar is of Mr. H.R. Choudhury. It's in a bad condition. So. And this, what do you call this, issues, if they're not attended to on time,
Yes.
And the state will also have to consider that in these foreigners tribunals, people mainly who are attending there, the litigants, they're from poor class of uh, people, and then there are huge requirements. Last time when he gave, since then we have come across other orders of the Supreme Court also requiring rooms for baby care.
Yeah.
Those things are there.
Only, my lord, this revised format, if by the last order when your lordship modified the order and saying that 4 more items are to be included in the format,
Yes.
that has been done, but then it is mentioned here that replies received from Dhubri, South Samara and Tinsukia. Further reports received from 5 districts are in previous format. Incomplete report from 1 district. It is proposed to send a reminder to the districts to expedite submission of the replies. This is the reply. And with regard to the SOP, I think the SOP has been prepared. Page 3, the SOP has been prepared.
Page 3.
Page 3, you will find under serial number 3A.
Yes.
A standard operating procedure has been prepared in consultation with the so standing counsel for FT and border areas. A copy of same is enclosed as Annexure 2. That has been prepared.
Because unless you start also a complaint mechanism, because we have shown you on the last occasion, the records show that applications were filed.
Particularly that review petition. Yeah.
Then they are returned.
Yes. They have
it's
no
not registered
procedure.
anywhere.
Yes.
So at least in the Home Department, there should be a email ID so that people who's, you see, what does a lawyer require? They require only that their case should be heard.
Yes.
So if petitions are filed and then they are not accepted by the tribunals musically, then it affects the justice administration system.
And the issue regarding my page 6 at serial number 7, your lordship, by the last order indicated that how the FT of Kamrup district is functioning from the metro. There your lordship.
Produce a notification,
Yes,
but that doesn't justify the tribunal here.
yes. Only one thing at page 6, if your lordship finds the right hand side mirror, the second column. Last paragraph says further it may be stated that FT Baksa and Tamulpur is currently situated in the newly created Tamulpur district. That does not.
Newly created Baksa district.
Yes, it is for Tamulpur, newly created Tamulpur district.
Which one?
Page 6 of this.
Page 6, yes.
Serial number 7A, right hand side,
7A.
second column, serial number 2 after that.
So it may perhaps say the FT Baksa and Tamulpur is situated in the newly created Tamulpur district.
Yes.
So then in respect of the item number 2A,
My lord.
we propose that the authorities from the PWD,
My lord.
Public Works Department, the officials of the Public Works Department,
My lord.
they will just join us in video conferencing on the next date.
Yes, please. The Lordship will pass a specific order.
Yes. At the, person at the rank of joint secretary or PWD,
Let it be joint secretary.
and the chief engineer PWD, they will join in video conferencing the next day for
Right.
infrastructure matters.
Yes.
To be right by one.
Somebody from the home department, because previously they used to come. Perhaps,
We did not require because we have, since the
Because this
Additional Advocate General is appearing and
Fine.
they have been, uh, rather there is no deficit on their part for the time being.
True, my lord. Fine.
Because if an infrastructure is required,
Yes,
then perhaps we do this because it will be the PWD to
implement, yes, my
implement
lord.
it.
Yes, my lord.
And the and the requirement where is that? So wasn't that, compilation was filed on 19/11/2024 by Mr. Das. Regarding the pendency.
Yes. Yes, ma'am.
You could share. So it will-
Yeah.
Now, in Barpeta one, there are 3,036 cases with 113 disposals only.
Yeah.
Now, this 3,000 cases will take 10 years. No, not 10, 20.
Regarding this, I think they have got somewhere that they have transferred some cases, maybe. Here it has been mentioned. This page 6, 7, page 6, 7C. Concerned authority shall also examine, your lordship direction was the concerned authority shall also examine if there is no requirement of a tribal in the rural areas of the district of the Kamrup, whether the same can be abolished and the tribunal will be constituted in one of the districts which have very high number of foreigners tribunal cases.
Annexure A of the report submitted by my senior. Annexure A. That it keeps the data, my lord.
Annexure A.
Yes, my lord, this one.
Yes,
Ah, yes.
annexure A, yes.
Annexure A. Now you see. Cases, for example, Barpeta, FP1. Earlier it was 3036. Now after transfer, it is 2909.
Yeah.
And with transfer of 884 cases. So therefore, there is some mismatch in the data. 2909 plus 884 is
There see.
3793.
2909.
So 3793, 3036 minus
884.
you see, we are looking at the, this comparison of 1911.
Yes, 1911.
And now we are juxtaposing this with the data is now provided. So 2909 in your annexure A.
Yes.
and 884 cases transferred.
Transferred.
If we add these two,
Ah.
that means the cases in the perpetua FT1 would be 3793.
Yeah.
But you have in the starting of the year, you had 3036 cases. That means there's a mismatch of 787 cases. We don't think in this year, 787 cases have been registered.
There's some mismatch. Because this was prepared in November 24.
This is 24, now we are at November 25, 1 year.
1 year. And here, when in the annexure A, they are saying pending cases as on 31st March 25,
Yes.
2909.
So number of cases transferred
Yeah.
is before that or prior to that? Sorry, later to that.
Try one. এইখন নে এইখন থাকিব চাচোন আছে নাই না
In this letter of annexure 3, we are saying that we'd like to mention the interest of early disposal of pending FT cases. FT members may perhaps be transferred to Jorhat, Sonitpur and Udalguri. FTs from other FTs. But this is, Borpeta is very high. Then again, you see the last page of your, this compilation, before that notification,
Yes.
the summary of pending FT cases transferred.
Yes.
What does this mean? This is figure again, which is not matching with your earlier annexure A.
Yeah. This time it is 3281
3281 is total. Acha, this is total,
total.
total of the district. So according to this page, 3281 is of Borpeta, Kachar is 1195, Dhubri is 1058, Morigaon is 1100. They intend to transfer Jorhat, Sonitpur and Udalguri. Cases of Jorhat has Udalguri and this Sonitpur, they have not been identified. No, I think Jorhat and Jorhat has the FT. Their data is not here.
Jorhat is not mentioned here.
It deals with Golaghat also, right?
Yeah.
Cases of Golaghat are being tried in Jorhat.
Yeah.
But we don't have the data.
On top of this document, they have mentioned summary of pending FT cases transferred.
We understand, but you see the earlier lecture A
Yeah.
is also transferred. So what is the pendency? We don't know.
Yeah. Pendles. Now. Jorat is not there.
Jorat, in the comparison earlier given by Mr. Das.
Yes, Jorhat, Sibsagar, Choraidev, Golaghat and Majuli.
These are the functioning of that Jorat FD. It is quite high. And please come to page that affidavit of the comparison of Mr. Das of 1911-24 at page 5. You got it?
Yes, taking.
Page 5.
Yeah,
Kamrup, you see, Ulubari, Guwahati has 340 cases.
yeah.
And Amilgaon, he has 1079 cases. So tribunal at Guwahati is not correct, unjustified.
Amingao, 3 is having 3 times the number of cases in Ulubari, Guwahati.
No, you see, I don't know because, but in the course of judicial proceedings, we have come to know that, for example, in Kamrup rural,
Yeah.
there's a place called Nagarbera.
Nagarbera.
People say that it's easy to commute to Guwahati than to go to Amilgaon. That is what I was told. Right or wrong, I don't know. The question is that in these 340 cases,
Yeah.
we'll have to identify whether these are closer to Guwahati and therefore they can come here, or these are old interior places that can otherwise could have communicated to Amilgaon.
That we'll have to find.
After this data, some fine tuning is further required, my lord, with regard to my lord, the implementation and segregation of the cases, my lord.
And updating also the present status.
No, but see, there are few things you'll have to tell us. In an monitoring bench,
Yes,
can we also go into these aspects?
ultimately your
Normally,
lordship is
Normally, my
considering
lord,
the,
whatever cases which are pending, whether those cases are being properly conducted or not, that will directly come within the
Yes.
purview of this monitoring bench. For the rest, possibly,
No, that and infrastructure also, you see, if there's a disparity, 340 in one, thousand,
Yes.
What do you call it,
1079.
1079 cases in 3,
Yes.
it's not an equitable distribution.
That also comes.
And
no, that comes within the functioning of the tribunal, my lord. That your lordship can take into consideration that.
Because you see, we are, unless the strength is improved or increased
Yeah.
of the judicial officers, or in the, tribunals, presiding officers, you see what is happening. You take a CBI prosecution. Once a threshold of 50 is crossed, the CBI recommends taking up of one more court. So if certain principles like that is not applied here, 3,000 cases would mean 20 years.
Yes.
And look at all these cases in your compilation. Is come to that Borpeta. 3281 cases.
Borpeta first.
Yes, ma'am. Yes.
Please come to the that comparison of 1911.
Yes.
Borpeta 1 itself has 3,036 cases. Borpeta 2, 1771. Borpeta 3, 2378. Borpeta 4, 277. Borpeta 5, 2712. So therefore, I can count more than 14,000 cases here only.
Yeah.
And this
And
data
it's-
is of as on August 2024. Thereafter, by now,
There may have been increase also.
Hmm?
After August 24,
We'll direct all the foreign tribunals also to give their individual
It is better.
penalty cases.
it is better.
We-
We get the exact picture.
আমি তো active করে পাইছি।
How we are getting it?
Home and Political.
How we are getting it?
Earlier, we prepared this on the basis of report submitted by Home and Political Department.
Home and political.
Yes. Basically, Home and Political Department perhaps asked the FT members and thereafter.
Mr. Chaudhary,
এখন
today
তো
again you are
FT
trapped with
border-এ-
this foreigners cases. Your review petition is unlikely to be taken up.
Your Home Department give,
No,
issued
we'll
communique-
excuse the senior counsel. If we
Yes.
cannot take up his case, we don't want to keep him waiting. When, tell us the date. 18th of November, 18th of November. Is there any special bench on that day? Right. We're fixing it on 18th, subject to your convenience,
10. This month.
this month.
One day a bit earlier if possible.
No, next week I'll not be here.
No, not, that's a timing matter. Oh,
That can't
it is
happen.
only, any matter, that the lawsuit,
Today,
Kendall. That's, we find it, madam, yes. That of course we have nothing to say, madam.
After that,
Also convenience, madam. Item 3.
বুঝি না বল।
Yeah, yeah.
বুড়ো লাগিছে।
I'll check the right for the.
Arun sir, one of the attackers.
Yes, he is also one of them, I guess.
Amicus not.
Amicus.
DDB.
Next is the two. Elisa, he was put at the upper. No government of work, but it could be, he's suffering from serious liver problem. He wanted transfer to local court. He has been transferred to Udalguri. So he wanted me to play with people for. They treated me for the Papa de Vega, the court. Then to the over by the. We can. Read. Copy of an law. Logical. No, kindly record sir's name, I am SSDK. Delete that devolution, huh? Yeah, rest of it. Okay.
Foreigners tribunals and come up with a proposal of how this infrastructure requirements of the tribunals would be met. Full stop. The state is, the next para, the state is also put to notice that in the event there's any requirement of the finance department of the state, comma, the court may also impede the finance department of the state so that the infrastructure related issues can be addressed in an appropriate manner. Next, in respect of point number 2C of the order dated 2/9/2025. Oh, Mr. Das and Mr. Mazumdar, I had just forgotten, there's a meeting at 4:45. I'll raise the or draft order. You can, in the morning, you can see it from the court master.
Very well.
If you have any suggestions, we'll correct it in the afternoon.
Yes.
During lunchtime.
Well, two more small issues are there. I'll not, I'll place the documents, my lord. Lord, so we'll have a look, my lord. Then
Just tell us what is it?
one is with regard to, my lord, clarification regarding authorization of UDA come accountant to sign notices and summons and official correspondence in foreigners tribunal. There are some difficulties because it says that which is basically UDA assistant, which is a non-gazetted grade 3 ministerial post is instructed by the presiding officers to sign the notices and summons issued in the cases under adjudication as well as official letters used by the correspondents in various administrative matters under by order. In this regard, we seek to understand whether a non-gazetted ministerial staff such as UDA cum accountant can formally authorized by the presiding officer to sign documents and notices.
Well, that we, you see, if it just came across the mind. You see, a government is not going to appoint a gazetted officer to assist the tribunals for writing letters.
True.
And if any government authorities refuse to acknowledge that as a good communication, bring it to our notice.
Yes, my lord, fine. I understand. And another is with regard to, my lord, we have received one representation from one of the publisher regarding furnishing of the back volumes. Because books, my lord, because state cannot come up with a stand that in those 2-3 years wherein, because initially there was an order by Honorable Justice B.K. Sharma that it will continue till the tribunal is there. Thereafter, my lord, it stopped, and state cannot come up with a stand that during those 3 years, no law has been laid down by this honorable court, which will assist the tribunals in deciding the opinions. So in that view of the matter, Lordship the state can have a call with regard to this.
Yes. Last time, I think you extended the.
Extended.
But there are back volumes to be purchased.
Yes, my lord.
What period is that?
It's for 2020 to 2024.
Oh.
5 years.
Yes, Mr.
Because it discontinued, and there was a direction by this honorable court in monitoring matter only that it will continue till the existence of the tribunal.
This
Books are important.
Back volumes, otherwise all right, there may be also very good judgment. The problem is with back volumes, there will be a requirement of space also. When some of the tribunals are functioning from rented accommodation, the back volumes will again create the problem.
But you'll have to think of something. Either this or you'll have to provide them laptops and the e-volumes.
E-volume.
That's perhaps also the reason why Mr. Sharma faces difficulty in the bench. Because the tribunals don't know the orders which we are passing, and then these are not complied with. Even today, we had to remand a matter because one of the witnesses the recorded was not considered by the tribunal. He writes everything except for one word, examine the evidence of DW2. Except for that, he has written everything very beautifully. But missing of that word, and there are orders of this court which says that the evidence, whatever is there, has to be evaluated. Okay, you just put up this.
Yes, I'll place this.
Give it to the purpose.
Yes,
sir.
yes.
You pass orders. Kindly check up the orders tomorrow morning.
Tomorrow morning.
The next date would be fixed on 2nd of December.
Fine.